joyride and left all their contacts, and they were calling people, and it's very easy to trace back who stole a car when you have the entire contact list. But yeah, it's a whole new world out there when it comes to data forensics, which is a little bit.
I actually had a Tesla case I looked at, and we went back and found that she wasn't hitting her brakes.
Oh,
You know what I'm saying? Like,
yeah.
there was an issue, and the computer had it. They GPS took it straight to Tesla before it came back to the car, and we were able to figure out that there was no case. So
everything's recording it. All right, we're done. No, just kidding.
Everything's recording, we're done.
So, Califorensics, the name's a little bit, it shouts California, I understand that. That's kind of where they were founded about 13 years ago. I am based in Texas. You kind of need to be based in Texas to have a Texas PI, and therefore collect data that, electronic information that can be used in court. So I'm the Texas representative. I'm too new to have any effect on changing the name, but working on that. We are technically an e-discovery company, so we do assist law firms and lawyers with electronic data, preserving it, analyzing it, searching it, and then reporting on it. That's a little bit about what the company does. I've been doing this for 13 years. All forms of computer forensics, from computers and servers, thumb drives, cell phones, nowadays cars. The gamut just grows bigger and bigger every year. I do have experience testifying here in Harris County. Pretty much civil, IP theft, oil companies, those types of cases are pretty much the bread and butter, at least in downtown Houston. Today we're going to talk a little bit about the ethics of e-discovery, or ESI, as we get into it. We're going to go through basically just some guidelines to be aware of, how to determine if you know enough about electronic discovery to adequately put on a case, or if you need to hire someone, when do you need to do that. Timeline, if we get to the end, we'll have some examples of cases. All right, let's start with a few quick definitions. We'll start with ESI, electronic stored information. Pretty much anything that's stored on a hard drive, or any sort of, the law will say magnetic storage or electronic storage nowadays. So it can be anything that's on tapes, it can be anything on hard drives, cell phones, thumb drives, cars, cameras, just about anything you can think of, and even some things we're not thinking of yet. Amazon Alexas, people probably didn't think about those a few years ago. Nest thermostats, we didn't think about those a few years ago. They're all logging information, movements, non-movements. Fitbits, if you're familiar with that case where they use a Fitbit to determine when a heartbeat stopped. All this kind of information is being used by either law enforcement or the other side, and it's coming into play. It's all ESI. As we just kind of went through, ESI can be many different devices. This is just a little form that goes through. It's definitely not exhaustive. This technology is changing all the time. New things are being created. Sources of ESI are a little bit less in number than types of ESI. It's almost limitless, the types of ESI. Anything from a Windows Word document, an Excel sheet, a PowerPoint, or a picture, or a database, or anything like a text message or an email. All of that is types of ESI. So let's get into e-discovery, or electronic discovery. If anyone in here is familiar with the EDRM model, it's essentially just a layout of the direction that electronic media goes. So it starts off on this side, information governance. If you have a large company, information governance is usually when IT determines if they need an email server or a file server or any computers. It's the very broad, all of your information in a certain location. That's all information governance. Identification, preservation, it's usually where a digital forensics person comes in to collect data. It's usually the first stages of an ESI case, followed by processing, review, and then production. The volume of ESI starts really high on one side, and as you cull it down using key terms, date filters, you start to get more relevant data out of it. It becomes a lot smaller. Anyone familiar with that, or a few? All right, digital forensics. This is where I come into the picture. Digital forensics is really just the discipline of removing information from these ESI devices in a defensible, repeatable way. We're going to take that information from the computer or the thumb drive or the phone. We're going to image it off. We're going to give it a thumbprint. We call it an MD5 hash. That way we can tell you that no information has been changed and that it's in the same condition now as it was when it was on the device to begin with. Very important because that's where the whole case gets built upon. Is that foundation that the data is exactly the same after it's been imaged as it was when it was done before. All right, then metadata. Metadata is the data that describes the data that you're looking at. So the property files on a file, the created date, the modified date, last printed date. It can be in an email. It can be all the servers that the email went to. It can be the time the email was sent and who it was sent to. In a picture, it can be GPS coordinates, if you have that enabled on a phone or a video. It can even be if that document was printed or not printed. Metadata is extremely important. It's the basis for why you would even hire someone to collect data. It's very volatile. It can be changed as you open a document or move a document from one place to another. You want that information to stay the same, so you can say this document was created on this date, or you can say it was modified after this time when it wasn't supposed to. If you're trying to prove a spoliation, that comes in very handy when the dates have all been changed, or you can tell when a file is deleted.
Third question.
Yes, sir.
With metadata, many programs have the ability to scrub metadata from the document before it's transmitted.
Absolutely.
Once that happens, what can you do, if anything, to determine what the metadata was, or will it just show that the metadata was scrubbed?
Most of the time, it just shows the metadata was scrubbed. An example would be when you upload a picture to Facebook or Instagram, it's going to remove the picture when it was created, last modified, what camera took it, or any GPS coordinates. That way no one knows that picture you took in your bedroom, where that bedroom is actually located. It came into play recently on a case we did where there were two parties that were marching. It was the Workers' Party in California, also known as Nazis, and Antifa came to say hi, and they stabbed each other. Everyone was taking videos and pictures. The police went to YouTube and a few other sites, the Antifa website, to download these videos, but when they got them down, they realized that there was no metadata associated. They didn't have the time and date when it was done, any of that information. So it comes into play. They weren't able to recover it. What they should have done is grabbed it from the original source, which would have been those cameras, most likely phones, that were taking the videos. But yeah, there's no way to actually recover that. They're actually writing over that information and just kind of getting rid of it, as you say, scrubbed. So as we move into, I guess, the electronic or ESI sections of the Federal Rules of Civil Procedure, Texas pretty much mirrored that. You can read through these rules. They pretty much go through the steps for discovery as well as the clawback or snapback provisions, things of that nature. The Texas rules are exactly the same. I printed them out and things so you can go back and look at them. They don't actually read
You're not going to make us read them all
No,
right now?
I'm not going to make you read them all right now. More of a reference. Everything we're going to talk about is based upon them, but we don't actually have to quote them. Because this slide pretty much goes against what everyone says you shouldn't do as a presenter, which is throw up as much information on the slide as possible. So we'll move on to competency. Competency actually just really means knowledge, your knowledge of ESI and where information is stored. When it comes to the ethics portion, really what you're trying to make sure is that you have a basic understanding of electronic discovery or the ESI that's related to your case. You want to make sure that you have the knowledge needed for that level of case. Some cases are not going to require any ESI knowledge at all. Some cases are going to be extremely heavy in them. We've seen that in divorce cases where one guy will come in and it will be a very simple divorce. You look at some bank account statements, they divide up a house and a car, and it goes away. The next time comes in, the wife accuses the husband of looking at illicit images. Now all of a sudden you're dealing with pictures on a computer. Maybe they were deleted, maybe they weren't. Maybe he looked at them, maybe he didn't. Maybe it was a virus, and that was his defense. Both divorce cases requiring very different levels of competence when it comes to e-discovery or electronically stored information knowledge. Moving on, there's 3 different things you can do. you need to gain more knowledge. That's always the best thing, because then we're all learning a little bit something different. I learned about the artificial hip replacement. That was awesome. You can get a consultant to come in and do that. Sometimes that's the easiest way of doing it. They're experts in their field. They can help you out. Not always the cheapest option, or you can decline the representation. Finally, be aware that if you do go forward with a case, you do not know enough about the ESI, you are running the risk of potentially turning over either potentially classified information or privileged information to the other side. We're going to talk about ways to avoid that in just a few steps, but that's kind of the downfall to not knowing what kind of information you're going to provide to the other side. So let's jump into it a little bit. There's 9 skills that we're going to talk about. And as we get into them, you're going to see how they kind of all build, but we're going to go in an order. We're going to go in the order of how you should probably think of them to make it the simplest as you're moving down the line. Number 1, we're going to assess the needs of the client. As we mentioned earlier, not all cases are going to require a lot of ESI knowledge. Not all cases are going to require an expert. You can do some of this yourself. You can do some of this by farming it out in the office. Other cases are going to require a lot of it. What are you looking for? Know ahead of time, or try to figure out a plan of where this information is. Say your case revolves around a bill, some sort of billing software. That can be in the form of a PDF. It could have been emailed to your client. They may have to go to the website and download it. Maybe it's in the form of a QuickBooks. It can be in any of those forms. If it's a communication, it could be an email. It could be a chat. It might be a phone call or a voicemail. All those are going to be different types of ESI. They're going to require different levels of knowledge to be able to collect them. A voicemail is much more difficult than an email, things of that nature. So know what kind of information you're going to need for the case. It's going to help you plan how you're going to collect it later on. Where is the information located? Does your client have it? Maybe the other side has it and you need to ask for it during discovery. Maybe a third party has it. You need to go to the phone company and get records. Or you have to go to the phone itself and get the text messages. Depends on what kind of information you're looking for. Once you know that information, you can know which sources are most likely to get it. Some things can get really confusing, like where do you go to get text messages? Say your client deleted them from the phone. Well, the phone company may have about 30 days worth of records. They may have a little more, a little less, depends on the company. Maybe you have to go to a backup. Maybe you need to go to who they were texting and get it from that side. There's always usually multiple sources for ESI, and you may need to be creative about where to go grab it. Number 2. Yes, ma'am.
Okay. So in regards to, let's say, these texts, you know, there's also like WhatsApp.
Yes, ma'am.
Okay, you might be touching on that later, but you know, that's really a hard software to get into or extrapolate that information from.
Yeah, we actually do a whole class just on cell phones, and WhatsApp is probably the second most popular, other than just sending an iMessage or a regular default text back and forth. Most forensic softwares are going to, by default, be able to parse out that database and get that information, along with Facebook chat. Google has one called Hangouts.
See, it used to not be able to do that.
Yes.
It used to not be able to pull out what app.
That's part of the challenge with ESI, right? Is as the phones or the devices get better, the software takes months or even years to catch up. We're always a little bit behind. It's always a cat and mouse game. Part of our cell phone class, as we talked about, is you stick that phone in airplane mode, because what you don't want is in between the time that you need it and when you do image it, an update to come on, update the phone, and all of a sudden the software can't image it.
So the encryption, so this software, or the app has encryption, that you don't have a problem getting into that?
We do if we don't have access to the user's passcode. So the user's passcode is the gate key to the entire phone. Without it, if you're on the civil side, you're really out of luck. It becomes a brick. If you have a criminal subpoena, you can break the passcodes. That's how the FBI got into the ones for San Bernardino. Is they sent it to a company called Celebrite based in Israel, and they were able to find a back door into the phone. It requires a criminal. You can't just say you forgot your password to your phone. Can you break into it? I've got lots of money. That's not an issue. Just break. Then they won't do it without a subpoena. has to be criminal, not civil.
I just have one other question.
Yes, sir.
And this, you might already have covered it. So like on a lot of these, like, let's say it was a divorce situation where you have like a dating website or even like a quote unquote Ashley Madison's website on there, you know, are you guys able to pull that conversation from that site or from those, or do you still need their log on?
A lot
Or
of
can you
times,
pull it from their phone or from their computer?
sometimes it's stored on the phone. A lot of times it's stored on the site itself. A lot of information is stored on your phone, but mostly pictures, text messages, your web history, so it'll be able to tell you went to the site, or your app history, which apps have been downloaded to the phone. Many of those apps don't actually store all of their information on the phone itself. You're pulling it down through the data, so you have to go to the site.
So you subpoena the what?
You can see-
on Facebook or
Yeah, but you can see the information that they accessed it, you just can't get to
Correct.
the conversation. That's sometimes the problem.
So we had a fraternity case where the pledge fell downstairs after getting drunk at an event and died, and they waited a while before they called the cops. All of the pledges in that class were communicating to each other, all in a group message. When the police imaged the phone, they didn't produce any communications at all. When we took a look at it, we didn't see any either. But then we saw a screenshot where they were using an app called GroupMe, slightly lesser known to WhatsApp or a few of the others, but it was a little bit less known. The software didn't parse it. It's the same software the FBI uses. It's the best if you want to ask anybody. It costs $10,000 a license. It did not process any of those communications. So you had to actually go to the GroupMe site, download them all, and that's how we get them. So yeah, no, when it comes to phones, there's 6 million different apps,
Yeah.
and no software is going to parse all of them. So you get lucky and unlucky with these third-party apps that are kind of obscure. You get unlucky in the sense that the software's not going to parse them for you, but usually these third parties are not well known, they're not supported as much, and they're usually not encrypted on their own.
Okay, thank you.
No problem. Yeah, if anyone has questions, feel free to shout out. So getting into a little bit more information very related to that, is you want to act. You want to put together a plan to send out your preservation notice. Once you have an idea of the type of information you want to send that out and make sure people start preserving it. Data can be volatile, meaning that it just lives in the memory of the device, like a phone or a computer. As soon as you shut it down, you lose that information. It can be ephemeral, which means that it exists for a period of time or maybe a size of a database, and then the oldest stuff gets overwritten as new stuff comes in. For example, the call log on an iPhone only holds 500 entries. So on the 501st, it deletes the very first call log and writes in the new one. And it overwrites itself. A lot of Windows logs are ephemeral. They'll overwrite themselves as they get bigger. It just helps save space on the device. They don't care that you're losing information. It's not something that they think you really need. Email is something we don't think of as ephemeral. But if you're in a large company, they usually have a size restriction, maybe even a date restriction on email. After a while, older emails will go away or become archived. Something to be aware of. Same thing with backup tapes. Backup tapes of servers. After a certain retention period, those are going to get overwritten as well. Be aware of your clients' retention policies when they overwrite their data, how long that data exists. Sometimes you have to act really quickly to be able to preserve it. And we know that spoliation can be recommended if you knew that the information was going to be overwritten or lost and you didn't do anything to preserve it. So it's kind of a big deal to know when those preservation timeframes are coming up. And that kind of plays into a little bit on how we preserve information. Just moving files from one place to another can change the information on them. Changing the information on those files overwrites other information, thereby causing deletion or destruction of files. So when you do decide to collect, maybe on your own, or you hire someone, make sure they use tools that don't change any of the information. They use write blockers. They use devices that prevent any accidental overwriting of the information. That's going to help you prevent and preserve the data appropriately. Chain of custody is very important as it kind of starts the process of when this information was collected and who's had control of it from that point forward. Analyze. So when we say analyze, we're talking about looking at the entire ESI landscape for your client. If they're a big corporation, they may have servers physically on site. They may have computers, phones, maybe even paper documents. They might use off-site servers, things that you don't have direct control over, but you still need to get the data from that third party. Maybe they're using a phone service and they need to grab that information from the phone service. You need to take a look at all those different things. Cloud storage is a new thing that's kind of come out in the last 5-10 years. It's huge. It saves companies a lot of money, but they lose physical access to all of their information. So grabbing it from the servers means you have to go talk to Rackspace or Amazon or wherever those places are stored, that email or that file server. Cameras, video surveillance, another important thing to know about. If your client has any of those, you're going to want to look into how quickly it takes before they start overwriting the last day's worth of video. And always be aware of new types. Moving on to step 4, talk to your client about what steps need to happen next when it comes to, are they going to collect the data themselves? Are you going to hire someone to come in and preserve it? Hiring someone allows you to offset the risk of changing the data to that third party. Sometimes companies are like, well, we have an IT staff, so we feel confident that we can do it. That can be a really great source of information. Usually IT, though, is not skilled or they haven't taken classes or are knowledgeable about ways of preventing data from changing. So they may use a tool like Robocopy, which will maintain some metadata, but as soon as it gets put on another hard drive, it's not in a forensic container. It can be touched, it can be manipulated, and it doesn't have any of the protections.
Is it forensic container?
Correct. So a forensic container, when a phone or a server or a computer is imaged by forensic software, it gets encased in a forensic container. Usually that's called an expert witness file. An EO1 or an 81 is the extension. That file will contain the hash of the data that's inside of it, and it prevents any of the information inside of it from being altered when you move it from one place to another. It's what we use to make sure that none of the information changes after we put all your information onto a hard drive, and then we back it up to another source. Then you want to find out where you want to keep the information. Always decide if the attorney wants to keep a hold of it or if they want a third party or even the company itself. This goes along with the chain of custody. You want to make sure that where you put the information is a secure place so that if you're in a very litigious situation, the other side can't start poking at who had access to it, were they able to change it, things of that nature. We kind of underline this. We do love IT. They are, don't allow this to be a don't let IT do anything type hate thing. It's not. IT is wonderful. It's our #1 resource when we go on site because we don't know where all this information is located. However, it's sometimes unfair to put IT in the position where they have to defend the collection of this data when they're in deposition or being cross-examined by the other side, and it's not part of their job description. It's not something they've been adequately trained on. Something to be aware of. All right, custodians. This part's the most exciting part. It's when you get to sit down and chat with the people who are most intimately connected to the data that you're looking for. It's also the time where you learn that they've communicated all this information to a lot of other people you never thought about. And your list starts to grow and grow and grow and grow. It's countless times we go on site and we think there's only 4 people we need to collect data from. And as you start talking to them, they go, oh no, I get those emails from HR. So now you have to go talk to HR, and then HR is like, well, we get that from the executive team. And it just grows and grows and grows. Be aware that as you interview people, you may find that different groups may be responsible, but different distribution lists can go out to a large group of people. So there's plenty of ways this information can, your scope can change, and sometimes you need to be flexible when it comes to that things. Not just other employees or IT, but third-party sources. Again, if you use QuickBooks, maybe you use the online source. You're going to need to be able to get it from the online source. If you use an IT company that's outsourced, you may have to get them involved, as well as any sort of phone records, things along those lines. Hosted application provider. Yes, sir.
How much information does an ISP retain?
Depends on the ISP. What we deal with mostly are going to be like cell phone records, and they're going to contain a fair amount of like cell tower information that phones go to. But we find that as far as like text messages and locations and things like that, as far as your IP addresses, it's a little bit more limited. Their retention policies are set up so that they don't have that much information. They don't want you subpoenaing them all the time for information. And you do have to be specific. Like if you want information from Google, you need to tell them exactly which. You want Gmail? Do you want your Google Plus? Do you want this, that, or the other? And you need to give them all the information or else they kick it back. And then by the time you finally get it submitted, your 30 days, they've already overwritten everything. And it's back to the races. Email, text messages, you may find that, for example, that fraternity case that we dealt with, a couple of people that we were involved with on the case deleted all their messages, but they were part of group messages with 5 or 6 other people. You can go to those sources and pull an email as well as backups from computers and things of that nature. So agree? This is when you get a chance to sit down with the other side during the meet and confer and decide to agree, hopefully. Sometimes it doesn't work out that nicely, on what types of ESI are going to be relevant. Maybe even a custodian list. Usually key terms are brought up at this point, and date times, or date filters, for being able to call it down. Don't allow the other side, we recommend never just do no matter how unique the acronym might be, a 2 or 3 letter key term. Those are always going to return just massive amounts of irrelevant data. Again, with that fraternity case, there were 325 key terms, and they listed every form of alcohol, every form of illicit drug. The word car was in there. When you search through a college kid's phone for the word jack, you're going to get a whole bunch of things. They had a keyword in there for lit, which I guess is a new word that the kids are using these days. Yes. Is it not new? At Baylor, it was new. No.
Yeah.
But it used to mean drunk, but now it's cool.
Now, or high, maybe? Well, that party was lit.
Yeah, now it means cool. It used to
Yeah.
Yeah.
Well, I guess lit shows up in a lot of words that don't mean what they wanted it to mean as well. So key terms are something you want to hash out with the other side beforehand, or else you're going to be stuck with hundreds of thousands of records that you're going through that meet all the requirements and are irrelevant. Yes, sir.
Just a quick example. I had a case. I was assisting with a very good litigator, and before he went into the hearing about the e-discovery, he'd already had the database of his clients, and he searched it for the terms that he wanted to get from the other side. He knew exactly what it was going to give, and that it was, bare minimum. And when he went to the hearing and the other side complained, he said, listen, we'll just do a search on these terms. And the other side had no idea what it was going to bring forward. And they had them sign an agreement that anything that came up would be relevant in municipal court. Unfortunately, on the other side, they had no idea what it was going to bring and dredged up all kinds of normally privileged information that was now agreed to be let forward in court. And they hadn't done the preparation ahead of time. They hadn't had their e-discovery set up in a database where they could search for it and know ahead of time what was going to happen with these particular search terms.
Yeah, no, absolutely. That happens all the time. And on top of that, I'm sure he probably indexed everything. Some people don't even index which is basically a computer program that goes through and knows if it's an A or a B or a C. And then you can run your keywords, and you're like, well, that keyword didn't return what I want, so you just hit another keyword and your result automatically come up. It takes a long time to index up front, but if you don't do that, you're doing a live search. Every single time you search that word, it's going to take 20 minutes or whatever to come back. You got to keep looking them up. So yeah, you want to be prepared. Key terms are very, very challenging.
What about the capability of having preceding or ending blank, like with
Right.
LIT space, as
Yeah.
opposed to?
You can do that if the software allows you. So what we ran into the issue there was when we tried to run that is all the data we were searching for came from a cell phone. And cell phones are inherently more difficult to search than an email, mostly because all the information in comes from a database. That database has to be parsed. And the software indexed everything, but it indexed spaces as well. A really good software that indexes is not going to index space or even short words like at or on. They're going to call those noise words. So we couldn't do any complex Boolean searches or any other types of searching for those words, and it just pulled up everything. So yeah, and while we're on the subject, searching text messages, not the same as searching email. No one speaks in correct English or incorrect language in the text message. They talk about that thing they did that one time with those guys, you know what I mean, that kind of thing. And so running key terms on cell phone data is not going to get you the results you want. You need to grab all the texts that are between the two people or three or four, the sources that you want. Put it in a date filter if you can, and then review for context. You just want to read through them. It's going to increase your review time, but it's going to be a lot more accurate than searching, unless you're doing a drug case. Drug cases are the one where they actually have unique words that don't mean what you want them to mean, right? And they do use those words in their communications a lot. But most people, when they're doing, sexual harassment cases or things of that nature, they're not using the people's first name or their last. It's, hey baby, how are you doing? That kind of thing. And they don't say Sunday night, June 23rd. They say the other day. So be careful with your searching when you start to get out of regular documents or emails.
Can I, this is just kind of irrelevant, but
It's
but
not.
I'm just curious because I know that I've even myself have had a message that went across and it was an autocorrect and then it autocorrected it incorrectly, and it came out something else than what it should have been. So do you have to look through all of those? I mean,
We usually recommend, if you do a keyword list, to include incorrect spellings or to pare the word down to its simplest part and then look for all variations of that word because of that very reason. Autocorrect in emails is a thing these days with Grammarly and a few things like that. And it can change it to a different word than what you meant.
Right.
Yep. So you have to be careful with misspellings. So let's see. So yeah, as far as the meet and confer, as you're going through the key terms, the custodians, all that information, you're going to want to agree on whether or not you get to search for privilege, non-privilege, communications, things of that nature. With a corporation, sometimes that's easier because they will have notices on the bottom or watermarks on documents if it's proprietary information. Makes it very easy to do searches for that information. If someone takes that IP to another company, you can just search for the specific words that are in those watermarks. Same thing in the bottom of the emails, something to consider. We talked about do not rely on the snapback. The snapback method means if you accidentally produce some information to the other side that is privileged or confidential, you do have 10 days to notify them and say, hey, we made a mistake, send it back. The problem is, by that point, maybe they've already read it. Shouldn't, but you did produce it. Don't rely on that method to keep anything confidential, especially if you're working an IP theft case or things where those are the most important. Let's skip this one and come back to it. Let's start with acquisition. So when we talk about the integrity of the data, and I mentioned earlier that you want to use software that doesn't just drag and drop files over. It encapsulates them, it locks them down so that they can't be changed. Whoever you hire or whoever does the work, it'd be best if they do use some sort of software that does that. It's very easy these days to use that. It's relatively cheap. It doesn't take up much space on a hard drive to correctly image these things. Phones, a little bit more difficult. They do require some specialized software and some specialized knowledge. But as far as regular files, there are things out there you can get for relatively cheap, or you can hire a company to come in and do it for you. As far as proving the integrity, as I mentioned, the MD5 hash is the only really best way of doing that. It is a fingerprint for the file or the group of files that you collected. And out of order, but the searching, as we mentioned earlier, searching is extremely difficult on text messages. It's very important. You want to be careful of your key terms. You also want to be careful that you're searching files that are searchable. Sometimes it's difficult to remember, but like PDFs, not all of them have searchable text inside of them. Some of them you need to OCR or use optical character recognition to go through and find the words before you can index and search them. Same thing with pictures. A lot of people will take pictures of whiteboards with their phones these days. It's just an honest thing we do to help us remember what was going on during that meeting, and we can go back and type up our notes. But then we go to another company and we have all that information still on our phone. So when we're searching through a phone for another company's IP, we're going to want to search through the pictures and make sure that they didn't accidentally take pictures of presentations, maybe different blueprints, things of that nature. You're going to need to use an OCR technology to be able to view those in a search. And then alternate spellings. That cascade searches is what I was talking about, the difference between indexing and live searching. When you have to live search, and you have to search every single time, it can take a long time.
It costs every time you do those searches.
If you hire an outside company, it's going to cost time. So usually an outside company is going to suggest that we index everything. That way you can change your mind a million times about the searches, and it will be a lot quicker, and therefore at the end, save a lot of money. Oh, I hit the wrong button. There we go. Technology is not my thing. All right. And then, at the very end of this, the reason we even go through all of this is to produce it. Most of the time, that's going to be determined during your meet and confer. If it's going to come in the form of a native file, which is just the email as it exists, the Word document, the presentation, or maybe it's just going to be TIFFed and Bates numbered. In that case, they just make a picture of everything and they include the metadata with it. However you want that presented to you, you need to ask for it in the meet and confer so the other side can comply with those. The courts do honor that. Again, native format is usually the easiest to read. However, if you have like an oil company client or someone who does drawings, sometimes electrical engineers or engineering platforms can be very specific file types that require specific software in order to view them. You can't just pull them up on any computer. You can't just review them natively. So be aware of what kind of ESI you want to look at. You may require, or it may require that you download a certain kind of software to be able to view these files. We actually had a case out of Lake Charles where they had a whole bunch of CNC machines and they had a whole bunch of drawings that they cut out of the metal, and all those were specific like NKT file type, which is just not something that Windows natively views. So we had to find the software that goes along with it to be able to pull those up and review those types of files. And then make sure you ask them to include all common metadata. What you don't want is for them to produce to you a PDF of a Word document and you don't have any of the metadata associated with it. It won't tell you much about that document, where it came from, who wrote it, when they last changed it. They can provide all that and they should provide all that information. So make sure that they give it to you. Make sure you ask for it. All right, let's skip the hypothetical case because it's in your notes, pretty honest. All right, so we'll jump into this a little bit. The timeline pretty much follows the steps we just talked about. As soon as you're aware of the case, you do want to start formulating what types of ESI you're going to be looking for. Whether or not they're going to be quickly, you need to preserve them quickly, or whether you have a little bit of time before you have to preserve them. That's the Johnson case, the Johnson versus, I think it was Walmart, where the judge ruled that in order for it to qualify for spoliation, you had to know that there was a good chance that information was going to be relevant and you didn't preserve it. Then it can be sent to a jury for spoliation. So be careful about that. These days, most cases probably involve some form of electronically stored information, some more than others. I think you'll see that as you go through. And if you have to involve an expert, maybe you don't have to. Be aware that the new forms of electronic stored information are coming out all the time, and that things are changing. Cell phones used to not be encrypted. They used to be very easy to image. Now they're all encrypted without someone's thumbprint or their passcode. It's just a bunch of data that's encrypted, and you're not going to be able to get the information from it. Email used to be very easy to grab from a computer. Now you have to go to the cloud and get it from 365. Things are changing. Things are always rapidly changing. When it comes to redaction, privilege logs, document review, you're going to go through all that with the other side during the meet and confer, and make sure that your e-discovery experts know what you're looking for, so you can tag it appropriately, and it'll make your case smooth as you're going through it. Let's see. So we kind of put this question up there: what can you expect to receive? Usually it's whatever you ask for. During the meet and confer, if you ask for native files, they're going to give you native files. If you ask for PDFs, they're going to give you PDFs, or maybe a load file. If you're using an e-discovery platform, you can take all those natives and all their metadata, throw it into a load file, and review it online. It makes things very easy. E-discovery vendors have a way of taking hundreds of computers, condensing it down, and letting you review and tag things as privileged or non-privileged as you go along those lines. This is another big question that we get all the time. How do I protect my client from unreasonable requests? Sometimes that first request is a shot across the bow. We've seen a lot of times that they want all emails dating back to 2004. And it's a ton of information, especially if you consider that some companies have a very vague retention policy. They have tons of backups they would have to go through to pull that information out. You're going to need to argue that just is unreasonable. Be prepared to know their retention, your company's retention policies or your client's retention policies, and be able to tell them, look, we generally just store information for 3 years, and that's it, or 1 year, if that may be the case. Good limited search terms. We can't say that enough times. Your search terms are going to help you out a ton when it comes to this data, unless it's text messages. In that case, you kind of just have to review it for context. And privileged, we touched on it earlier. If your company has watermarks on their documents, that makes it very easy. As attorneys, a lot of attorneys put the language in the bottom of their messages so you can easily pull those out as privileged. Try to search for any of that information first. It'll help cull the data set down. Finally, we talked a little bit about how cell phones are kind of specific. Other things, cars, Nest thermostats, certain types of databases, medical records, things of that nature are more difficult than just normal Word files or spreadsheets, PDFs to collect. Those are things you may want to consider if your case requires that information, reaching out to an expert to grab that information. And production. Production can be the easiest part, because you're just reviewing the documents and picking which ones are privileged, which ones aren't. A lot of e-discovery vendors are going to be able to provide you with support in that matter. If not, you can review the documents natively and put to the side whichever ones are privileged, but make sure you keep a log of which ones you're keeping out. Anybody have any questions on production? Or if you've had any weird cases where, no? All right, so we talked about spoliation a little bit. Trevino, that's an older case from 2005. It was that the company had the obligation, or should have known that they had the obligation to preserve the data, and but they didn't have to take extraordinary steps, the court said, to be able to do it. So it just needs to be a reasonable effort to preserve the data. It doesn't have to be extraordinary. Now, since then, the court has said that it's a lot easier to recover deleted data and things of that nature. So sometimes that falls into that it wasn't an extraordinary step. You should have taken a step to recover some information. We'll talk about a case like that in just a second. On the Johnson case, this is a case where a person fell in a store, and the store took so long to go back to the tapes and pull that data from the incident that it overwrote. Court said that they were really supposed to know that that was relevant information and preserve it, and I think we can all agree there. On Weekly, they only produced 31 emails. The other side certainly thought there were going to be a lot more than that. Court in this case said that you can hire an expert to help you recover information. It's not that much of a burden these days, and that they really should have recovered a lot more information than they did. And then State Farm. State Farm's a case where one side presented just PDF or TIFF images of files. No metadata associated with them. When they were spreadsheets, you didn't get any of the formulas or any of the other complex parts of those files. They were just static files. They claimed that they had to produce them that way because it was too expensive to do the other way. The court disagreed and said that you can provide native files and should, in most cases, provide native files. Or if it's not a native file, make sure you include the metadata along with it. So there's a few things you can review. At the very end is just some federal rules of evidence. And I think we're out of here about on time. If anyone has any questions, be happy.
I was just going to make a quick statement. I see a lot of this in non-compete trademark cases. If you get a TI requiring that your client immediately run down and dump everything on some third party, don't have him sign up to pay the bill. It's worth it to go to the judge and get an emergency hearing to say that people requesting this should be paying it. It was, I think last time we had it was 30 to 40,000 within 2 to 3 weeks.
Oh, that's fair enough because
I mean, the people who are requesting it should be willing to foot the bill if they're wanting to do that, right?
on our side, we see that all the time. I mean, 50-50 that the side wanting us to do the work will pay for it, and 50-50 that the other side's providing payment for the services.
Most of the temporary or junction or TROs won't actually specify. So it's well worth to get clarification, turn it over and get it. It saves your client a lot of money.
That's a really good point. All right, everyone. Thank you very much. I appreciate it.